Hi, my name's Anthony Turner. Today my guest is Jeff Brown from the Small Business Commissioner's Office, brought to you by the Small Business Institute. In a previous interview, Jeff and I were talking about what the Small Business Commissioner's Office actually does. One of the questions that we've actually got from one of our TSBI members is with the mediation process. They're trying to get a bit better understanding of what that actually means and what the process is that goes through. Just as a bit of a reminder for those that may not have seen the previous interview is that basically people who are in a dispute can actually come to your office, whether by phone or through the website. They can organise, if the dispute cannot be resolved immediately, for a mediation process, which is where the two parties come together in a room with a mediator to actually negotiate some sort of an outcome. Obviously, there's probably a lot more to it than that, just a very simplistic overview, Jeff. What is the actual process of how people come to getting to a mediation, and then how do they go through that process?
Well, firstly, to get there, it's necessary for both parties to be willing to engage with us.
Sure.
And I can't compel parties to participate in mediation. So part of the challenge often is to convince the other party, the respondent, that it is beneficial to come to mediation and resolve this dispute and avoid it going through to litigation. So we spend a bit of time talking to both parties and arranging a willingness to attend. Yeah. We then have to find a location, time and date that suits everybody.
Yes.
Unlike VCAT in the courts, we don't determine when you'll turn up.
Right.
We'll find a time that suits.
Yes.
And that may be you and your barrister and your lawyer, for example. So there's the logistics of managing that. And I'll appoint a mediator to each of the matters we deal with. I've got around 50 mediators on my list that I can call on, plus one on staff. And we will try to appoint the most appropriate mediator for that problem, that dispute, and often having regard to the parties. Many are lawyers, but not all. Okay. Some are based in regional Victoria. So the choice of mediator is a deliberate decision. On the day the parties turn up, we need to make sure that those turning up have authority to make decisions for their respective businesses.
Okay.
Otherwise, it's a bit of a waste of time. The mediator will also get them and the mediator himself to sign a mediation agreement.
Right.
Now
what does that mean, that agreement?
This is really saying how the parties will conduct themselves. So,
okay.
Good faith obligations. It has very strong confidentiality agreements.
Right.
So that what's said or offered in mediation can't be subsequently used in the case of litigation, if that's where it goes.
Right.
There are protections for the mediator,
yes.
so the parties can't come back and have a change of mind and take action against the mediator. But essentially about how the mediation will be conducted under the direction of the mediator.
Okay.
So we sign that off. Usually the mediators will start by sitting with both parties in the one room, mm-hmm. and ask each party in turn to state their case, state their understanding of the issues in question.
Yes.
You can imagine quite often there's a lot of emotion at the start.
Yes, yes.
Because these disputes usually have been exacerbated as parties move further and further apart.
Yeah.
So there might be a bit of emotion, there might be a bit of legal positioning going on by the lawyers if they're present.
Yeah, I actually noticed that I was involved in a mediation with one of your mediators on behalf of, or assisting a client. And yes, when you've got the two sides there and there's been, the emotions have been building up over time, and each one is fairly entrenched in their position of what's right, and what the other one should do. It's probably not a very easy job for the mediator to bring it into sense, some sort of harmonious or harmony whereby they can actually talk to one another.
And it doesn't happen immediately, but the mediators are pretty skilled in what they do. So we start off with a joint session. Each party will state their case. Often the mediator will play it according to each case. So sometimes they'll stay in joint session for quite a while, right. if the dynamic is working. Yes. But at some point they'll usually ask the parties to go to separate rooms. Mm-hmm. And then the mediator really goes backward and forward, clarifying the issues. In some cases may suggest that perhaps a party's position is not as strong as could be the case. Right. And more often than not, in any commercial dispute, there's some give and take. There has to be some give and take. It's rarely black and white who's in the right and who's in the wrong. Yes. So the mediators are very skilled in suggesting those risks to both parties. Yes. And encouraging a commercial resolution. And of course, if matters do escalate, and that means going off to VCAT or the courts, yes. That will usually cost time, money, angst, and you'll be waiting for 6 to 9 months to get your day in court. Yeah. So there's some fairly influential arguments mediators can use to try to get parties to put aside their entrenched position and just see that there may be some negotiating space.
Now, once assuming that some sort of resolution is actually found on the day in the mediation, how binding is that, say in comparison to a court or something?
Well, what will happen, if the two parties agree, they'll sign terms of settlement on the day. Right. And that will list a whole series or specific steps or commitments or obligations that each have agreed to enter into to resolve that dispute. Yes. It becomes a binding civil contract. Okay. So if either party breaches their obligations, yes. The other party could go to the relevant jurisdiction to get an order. Okay. My view is that most of our mediations, the settlements are honoured, mm-hmm. because the mediation process is such that the party doesn't have to settle, and if they do settle, it's usually because it's in their best interest to do so.
Right. Yes. Is it possible, or does it happen, Jeff, that you get a business owner that might be in dispute with, say, a couple of different other businesses? That would they be handled individually, or would those disputes, or would they be maybe collectively handled?
Depends on the case.
Yes.
I can recall one case we had. I think we had about 12 or 13 owner-drivers with a dispute against a hirer. Okay. And we had about 12 or 13 owner-drivers turn up to the one group mediation. Right. And that was settled. And the reason it was done as a group was that essentially they each had the same problem, the same issue. Yes. And so getting a settlement in principle applied uniformly across all. More often than not, individual mediations will be conducted, because more often than not, each individual case will have some nuances to it which don't apply across the board, and it's very hard to get a group decision in those cases.
Yeah, cool. With things like mediation, I mean, we hear about the costs of courts and VCATs and everything else. How does the cost of going through a mediation process through your office compare with those?
Well, firstly, we can set up a mediation as quickly as the parties are willing to hold it. Okay. So if you and the other party are willing to mediate within 48 hours, we will set that up. Okay. Normally it takes 6 to 8 weeks, and that's just the logistics of organising it. Yes. So from a time point of view, that compares with 6 to 9 months in VCAT or the courts, okay. Waiting time. In terms of cost, we charge for most mediations $195 per party. Wow. That's a subsidised rate, yes. Much lower than most of our mediators would charge in the private sector. Yes. And this is to keep businesses out of litigation. That's the primary policy intent. If matters don't settle or parties refuse to engage, they can go off to VCAT or the courts, and that will cost substantially more than $195, sure. Both in direct outlays and the amount of time and effort involved. And we've found through research that particularly businesses employing less than 5 people, right. The adverse impact of litigation process on their health, their stress levels and their business are significantly higher than for the larger businesses.
Okay, that's amazing, yes.
Yeah, it's quite significant.
Are there any things, Jeff, that you cannot or do not mediate?
Well, our core is business to business.
Yes.
You don't have to be an incorporated business, so sole trader partnerships fall into that
right.
category, but it's business to business.
Yes.
Or business to government.
Right.
Although our history shows only about 2% of any of the disputes we've received since 2003 yep. involved a government body of some sort. Yes. So they're fairly rare. And not-for-profits I'd put into the banner of businesses okay. as well. Yep. So an association against a landlord, for example, yep. Would be equally valid. We don't do business to consumer. Right. That's consumer affairs. We don't do business to employee. Yep. That's fair work. Yes. But we do business to business.
And my understanding is that as long as my business or one of the businesses of the parties, of the two parties, is in Victoria, then you can operate. But you can otherwise parties have to be all in Victoria, or have I got that correct?
No, provided there's some connection to Victoria,
Yep.
we will engage if there's an interstate business involved, for example,
Yes.
and occasionally overseas businesses. A lot more difficult to deal with, as you can imagine. But I recall last year we had a dispute with a Canadian company. We held mediation by phone, and that was settled. And the Canadian businessman gave us very strong positive feedback about the process. So it's not impossible. But normally Victorian-based businesses or Victorian in another jurisdiction. And I should mention that there is a small business commissioner doing a similar role in New South Wales, in Western Australia and South Australia.
Yes.
So between us, if one party's, for example, in New South Wales and one's in Victoria, those bodies have the choice of which commissioner they go to.
I guess it depends on who's the complainant and who isn't.
To some extent, although it may be that because of geographic location, it's easier for the parties to go to Sydney rather than Melbourne, and we're quite happy to refer those off.
Fabulous. All right, well, Jeff Brown, thank you very much for spending some time and explaining the mediation process that you handle on behalf of clients.